So my name is Sean Vitka. I'm the counsel for Demand Progress. As part of that work, I serve as director of the Fourth Amendment Advisory Committee. We're putting on the panel today and panels generally to provide policymakers with more information, especially views from outside of the Hill. With that, we have a wonderful panel today. Quickly introduce everybody. To my right, we've got Jumana Musa, who's the director of the Fourth Amendment Center at the National Association of Criminal Defense Lawyers. To her right is Marcy Wheeler, senior fellow at the Center for Cyber and Homeland Security at George Washington University and author of EmptyWheel.net, and you may know her best by her Twitter handle, EmptyWheel. And then to her right is Sandy Fulton, Government Relations Director for Free Press. Before I kick it over to the panel, I just want to set some of the framework for what we're talking about. And so to understand what we're talking about today, to understand Section 215, we have to go back and look at some of the history of American surveillance. And American surveillance, domestic surveillance, has an unfortunate history of being both unlawful and problematic for a variety of reasons. This, in the 60s and 70s, looked like people like J. Edgar Hoover spying on people and violating the constitutional rights of people like Martin Luther King Jr. In response to that, Congress passed the Foreign Intelligence Surveillance Act of 1978, which significantly curtailed that practice for domestic purposes. But then the September 11th attacks in 2001 happened, and Congress moved to punch some holes in FISA with the PATRIOT Act. So, after 9/11, we have this period of about 12 years. And what we would find out eventually is that even before the Patriot Act was passed, the executive branch started a program known as Stellar Wind. And Stellar Wind collected the content and records of both phone calls and internet communications in violation of FISA for 6 years. In 2006, with a number of senior Department of Justice officials threatening to resign, the government decides to move those authorities, to move that program, and to split it up. So they split it up so that there are different, so each part of it goes to a different legal basis. So one part of it, the bulk telephone records collection, moves to something called Section 215, an authority that was established by the Patriot Act and was largely unused until that point. But starting in 2006, the government begins to secretly use it to authorize the collection of all phone records of all customers of the major telephone companies in America. This operates in secret for about 7 years, until 2013, when the Snowden revelations reveal it. So the first thing you heard about from the Snowden revelations was a program authorized by Section 215. In 2015, Congress moves to restrict that practice, and they ban bulk collection, but in passing the USA Freedom Act, they also establish what's called two hops collection. And in that, what two hops collection means is that when the government is surveilling a target, they're collecting not only the records of that target, but also the records of anybody who's in touch with that target. So that's the second hop. And what that guarantees is that the vast majority of people who are spied on using this program, this part of Section 215, are neither the target nor anybody who's in touch with a target. In 2018, this redounds to the collection of 434 million phone records related to only 11 targets. So in 2015, we have a significant move by Congress to restrict the mass surveillance being conducted by the NSA, but in 2018, we still have this incredibly massive amount of collection. At the end of 2018, the NSA reportedly shutters the program. That's been finally acknowledged by the executive branch. However, the executive branch has also, just last month, called for permanent reauthorization of all of the expiring authorities under the Patriot Act, including the CDR program, with at least the possibility that they might want to restart it. I also don't want to be too narrow here. The CDR, the Call Detail Records Program, that's what the CDR program stands for, is not the only part of Section 215, and so we'll get into some of the other uses of 215 that are also concerning. So, we have a variety of new materials. They're available online at section215.org. You can also pick those up over there. The long report that just came out today is a chronology of violations since 9/11, and we unfortunately found that basically since 9/11, the government's collection of call records has never been fully compliant with the laws and rules that govern that collection. So I encourage you to check out that report if you can. Please take one home. And now I'm going to shift over to the panel, given the complicated history that I just did a very brief overview of. So, Marcy, why don't we start with you? Why don't you tell us what Section 215 today is?
Okay, so as Sean sort of alluded to, there's the CDR program, but that is a subset of Section 215, which is one of the three authorities that we're going to be discussing over the next several months on reauthorization. And you will hear over and over again over the next several months that Section 215 is nothing more than a criminal subpoena for intelligence contexts where you can't have a grand jury investigation or where there's heightened import on secrecy. And that is true to a point. So for example, if in a criminal context you wanted to go collect a bunch of phone records, you wanted to go get somebody's business records, you would go to the grand jury and get a subpoena and serve it on somebody. In the intelligence context, there's no grand jury, you want more secrecy, and so you might be asking for precisely the same things that you would be asking for with a grand jury subpoena, and they might be, as they are in a grand jury, tied to an individual suspect, tied to an individual investigation, tied to, at the very least, in a counterintelligence context, tied to, say, the Russian threat or the Chinese threat. But in addition to that, there are bulky uses of this. So in other words, not tied to this individual Russian ambassador who is talking to a bunch of Americans that looks really suspicious, but instead, here's a practice that we find suspicious, or here is a kind of function, such as using wire services to spread money around. Or buying beauty supplies that also happen to be precursors for explosives. And in the past, Section 215 has also been used to get records on that kind of activity, both wire transfers and beauty supplies, things like hydrogen peroxide and acetone. And the reason that's a bit problematic is because the overwhelming use of those purchases, of that activity, is completely innocent. So it means that the FBI, in the guise of searching for terrorists or spies, is collecting the records of the activities of entirely innocent people, and you don't know what's going to happen with those. And then the third thing, as Sean mentioned, is the CDR program, which was rolled out in 2015 to replace a bulk dragnet aspiring to collect the phone records of every American. It is tied to and codified. I mean, they were doing 2-hop collection and even 3-hop collection before that, but it did codify this collection of friends can have their phone records monitored and captured. But what happened is it became huge. Because for the first time the government had to put numbers to this collection, it became clear to the public just how huge the impact was. And even still, as Sean mentioned, the vast majority of the people affected are going to be completely innocent, not tied. CDRs are only used in the terrorism context, not in the counterintelligence context, but the vast majority of those people are not tied to any active plot or anything like that. But of course, that would tend to collect on people who have ties to other countries, to people, Arab, South Asian countries. And so that's one of the reasons that's concerning. The government says they're not using that anymore. But nevertheless, the government wants to reauthorize that. And I think we can talk about, you want to introduce the other two unused provisions, or one's used, one's not used, allegedly?
Sure, so two other provisions, and I think at least one of which is also the reasoning for has been outpaced by technology, is one is the roving wiretap provision, right? The idea that there's somebody that is critical that you need to investigate, but you can't just tap one phone because they may go down the street and use the payphone, and they may go over to someone else's house and use their house phone or something else. So then the idea is the wiretap attaches to that person, right, and not a particular telephone line. I think the reality is, I just went to the restroom earlier and walked past what used to be the payphone booth, right, which is now just like a little closet you can close yourself in and have a private conversation on your own device. Because that's generally how people operate. If you think about how many people have a home phone, so to speak, versus a cell phone, it's not so common anymore. But at the time this passed, it was, right? So the idea was you have to tap this person. They're going to keep switching up where they are and where they're making their calls, so the wiretap should flow with that person. What that also means is that anybody else who uses the device that that person may use, because you can't be sure, will also be wiretapped. And that's extremely problematic on its face. So I think, as something that is seemingly not used very often, or maybe it's used very often, there's not enough transparency about these things. The technology has already made an argument against it, and the possibility of collecting the very, private conversations of people who have nothing to do with a wiretap is real and critical. And I think all this needs to be thought of in the context of course, I'm going to say this, the Fourth Amendment, right, which was established to keep the government from doing these broad fishing expeditions where they just generally decide to search and see what they find, and if they could shake something out, maybe charge somebody. It was exactly a reaction to that kind of dragnet searches that we had a Fourth Amendment that developed in this country. The second provision is what's known as the lone wolf provision, right? Because FISA authorities, the idea behind them and the idea behind being able to access this information at a lower standard than you would in a regular criminal investigation is that you're tying an action to a foreign terrorist organization or a foreign agent, right? Somebody outside the country. This is somebody who's conspiring, even if they're in the U.S., they're conspiring with a foreign agent. They're part of a larger scheme or plot. In the wake of 9/11, someone said, but what if somebody is, sitting in their own home and hatching their own plot all by themselves, right? Not attached to a foreign terrorist organization, not a foreign agent, just somebody in their house who has some bad thoughts about something they want to do, that they need a provision for that person alone to be able to go and monitor their communications, again, at a lower standard than a typical criminal investigation. This, we're told, has not been used. However, we need to keep it. I think, for those of us on this panel, I know for those of us, the National Association of Criminal Defense Lawyers, anytime the government says, we've never used this authority, but we really must hang on to it, we view it with suspicion. Because it's either like, if you don't use it, why do you need to hang on to it? But do you really not use it? I get that this is a skepticism that comes with our point of view. But realistically, I think what we've always seen over time is that governments seldom like to return powers. Even administrations who will criticize past administrations for their use of the powers will think that they can use it better. Like, they'll use it responsibly, not like that other administration they didn't agree with. And that happens on both sides. But realistically, the idea of someone being a lone wolf, just finding that person, right, or identifying that person outside of being attached to, one of these larger groups or schemes, I think is very much the needle in the haystack. But what it really does is open the gateways to doing more investigation of people at lower standards. And we know, sort of as time has gone on, what has happened is FISA warrants have outpaced traditional warrants in this kind of communication monitoring, which is what we always see, which is when law enforcement finds that there's an easier avenue to collect information, they will always find a way to fit their work into that easier avenue rather than having to reach a higher level of scrutiny.
Well, in the lone wolf provision, there's reason to believe that's used not because they're using it, but because an argument they made to the FISA Court back in 2007 relied on, well, Congress said you could do this, so obviously you can do this, and a bunch of surveillance has been built up around it, relying on the underlying premise, but never actually, A, making that logic public, or B, going back to Congress and saying, do you agree that this new use of that is worthwhile? But 215 is another lesson of the dangers of leaving unused authorities just lying there on the books, because up until the time they did the phone dragnet, they had used it. There were two individual orders, once before 9/11, once between 9/11 and 2004. From 2004 to 2006, they used it kind of as a piggyback to collect location data, also not approved, and some magistrate courts kind of threw out that usage in courts. And then it went from those very limited uses to trying to collect everyone's phone records in the United States. It ballooned that quickly, and the efforts to balloon it that quickly didn't even involve a specific review by the FISA judges.
And that took 7 years to find out publicly.
It took 7 years and Edward Snowden risking his life to find that out publicly.
So just to recap, so on December 15th, we've got these expiring PATRIOT Act provisions, as Jumana helpfully just walked us through. One is roving wiretap, one is the lone wolf provision, and one is Section 215. So Section 215 has been the subject of the most controversy among them, but absolutely, as Jumana said, they are all important, and it's important to consider whether or not the government really needs these authorities. into the Section 215, back into Section 215, Marcy, can you give us a sense of the scope of the types of records? So 215 is specifically about business records. Phone records count as this, but what else fits under the 215 umbrella?
Well, we don't know. So if you're a staffer, you should demand that you get some transparency on that if you aren't being told that. But again, we do know that they've used it for wire transfer records. They've often talked about the need to use it for travel records, so for example, hotels. But the question is, are they going to the Hilton on a particular day and saying, you know, there was a terrorist suspect who stayed at your hotel on September 7th and we need everyone's records for September 7th? Or are they using it more broadly and saying, we need all of the records for all of the hotels, for all of the, I mean, this is an application that we know exists in the criminal side, so it wouldn't be surprising to see it on the intelligence side. In 2011, then FBI Director Robert Mueller confirmed that they had used it to collect acetone, large purchases of acetone and hydrogen peroxide. Again, household chemicals, completely innocent uses. Most of the uses are innocent. Beauty supply, people who run beauty parlors would be the kind of people who would buy them. Again, we don't know whether that was a specific response to the Najib al-Azazi attack or whether it was more programmatic. In the wake of the marathon bombing in 2013 in Boston, on a criminal subpoena, the government got all of the purchases of a particular kind of pressure cooker anywhere in the country. Because pressure cookers were used to cook to make bombs, but also pressure cookers are more often used to cook beans. And so it's unclear. That's the other kind of programmatic thing that one would worry about being used with 215. And again, we don't know whether it's a specific response. In the Boston Marathon case, it was, we know they use this kind of pressure cooker. We want to see who bought it. But we don't know if there's something more programmatic at the intelligence level, and those are the kinds of questions we should get answered before it gets reauthorized, particularly gets reauthorized for permanent, for good.
Thank you, Marcy. And before jumping to Sandy, I think it's worth flagging. I mean, it's always worth reading the statute and what's expiring. It's a bit of a complicated statute, but it's worth noting, I think, that, for instance, medical information is explicitly provided for under Section 215. So it's important to think creatively about how the government might use these authorities, because historically that's what they've done.
And it's defined as tangible things. So I've been asking for a long time whether they could collect DNA under this, or records about DNA under this, because that's a tangible thing.
Sandy, tell us about the politics of the situation. This is a controversial authority. Everybody's going to have to vote on it in Congress on December 15th or by December 15th. What are we walking into?
Yeah, thanks, Sean. Yes, we've heard a lot about these authorities, and we've heard the name Snowden thrown around a number of times. Snowden risked his life for this. So that was in 2013. I think it's clear that since then, over the past 6 years, we have seen very little success in actually reining in mass surveillance. And these were revelations that were shocking at the time. And while we have some very strong privacy champions in Congress, there does not seem to be the political will to pass a robust reform bill, much less let some of these measures just expire. Like, we build sunsets into all of these bills so that Congress can debate them again and see if they're necessary, because we know that they are massive, we know they are sweeping, we know they're privacy invasive, and we know that their effectiveness is questionable at best. Yeah, I mean, we're talking about the PATRIOT Act. Like, that thing didn't age well. Like, that's what we're debating right now. But I do believe that the Trump administration offers a change in that political dynamic. To be clear, I do not believe that any administration, Democrat or Republican, should have these authorities. But I do believe that this administration poses a unique threat to the most vulnerable communities in this country. This administration has been outwardly hostile to protesters, particularly those of color, to immigrants, to queer folks, to journalists. Like, I don't need to list them. This is all going down very much out in the open. Like, we know who is being targeted by this administration. And I hope that might embolden not only Democrats, but Republicans alike to come out who are representing like these vulnerable communities and put their voices like in this fight. And while I understand that not a lot of your bosses ran for office on a robust surveillance reform agenda, I do believe that your bosses will, I hope that your bosses will feel inclined to speak up publicly and to reach out to HJC, the Judiciary Committee, who is currently drafting this bill right now, and to encourage them to ask tough questions and encourage them to include robust reforms. And we are all here to uplift those voices, like in the hope of actually getting a strong reform bill around this time.
Thank you, Sandy. Could you, so Section 215 is an authority that the NSA and FBI are specifically the agencies empowered to use. So one side is the NSA, and that's where a lot of the debate has been. But I think the FBI has also not been, there's a lot of questions the FBI hasn't answered. For instance, in USA Freedom, they have carve-outs from a variety of the transparency requirements. So the NSA has to answer questions publicly that the FBI doesn't, when I think many Americans might think the FBI is particularly concerning, maybe more concerning than the NSA. So Sandy, could you tell us a little bit about your concerns about the FBI?
Oh, yeah, for sure. Absolutely. I think one of the biggest problems in Congress is that when we talk about law enforcement, we act as if it is a neutral actor. Law enforcement is not a neutral actor. It has never been a neutral actor. And again, this administration has taken all of that, I think, to the next level. We have seen leak after leak of the FBI targeting dissenting voices. I think it was just over 2 years ago that we saw the first report where the FBI had made up this entirely fictional black identity extremist, like threat assessment, or BIE, which suggests that people who are protesting police brutality are a national security threat, and that therefore could be subject to a heightened scrutiny. After that, the FBI testified they were no longer using the term BIE, and then we saw another leak that BIE was not just a threat assessment, but there was actually an informant program that went along with BIE called Iron Fist. And then just 2 weeks ago, it was leaked that they were spying on people protesting at the border. And again, they keep using this word extremist and suggesting that perfectly peaceful protesters are becoming increasingly dangerous. And this is despite any evidence to support this. And at the same time, they are actively deprioritizing investigating white supremacist violence. And to be clear, I am not talking about the ideology. No one should be subject to surveillance based on their ideology, but I am talking about the people that are actively arming themselves in this country and shooting people. And there are some in Congress who are trying to get answers around this, but they are being entirely stonewalled by this administration. Meanwhile, the FBI is coming to your bosses right now and asking them to give them the spying authority. I think it is perfectly reasonable, and if not just responsible of members of Congress to say that they will not do that unless there is some transparency and some oversight about what is going on at the FBI right now. I think that's my rant.
Marcy, why don't we switch to you as well? And Jumana, I'm rearranging one of the questions, but
you're going to confuse us, Sean.
I know, sorry. Marcy, talk to us about the impacts of surveillance, since Sandy just set that up so well.
Well, I want to counter not counter, because I agree with what Sandy said, but if you're a Republican, you should be just as worried about this. This Section 215 is not one of the authorities that everyone is talking about with FISA abuse. But according to the standard for targeting, somebody who has spoken to somebody who is targeted as an agent of a foreign power can themselves have their business records collected on. So Steve Bannon was in contact with Carter Page at a time when we know that he was under FISA order in early 2017, and that would mean, according to the standard for this authority, Steve Bannon could have had all of his business records collected in January 2017 just because he was speaking to Carter Page. That's the way this standard works. I don't think that happened, but that's a demonstration of the way in which the standard works. Something far more concerning, I think, and the way in which Section 215 probably, and these Section 215, aside from the CDR program, is used primarily in the counterintelligence world. The terrorism surveillance is happening increasingly on criminal orders. But from a counterintelligence standpoint, one of the biggest impacts we're seeing today is that completely legitimate scholarship conducted between universities in the United States and China, conducted by Chinese Americans or Chinese citizens studying in the United States, there is a concern about the counterintelligence, about China using our universities as a way to collect information in the United States. But nevertheless, there are numerous examples of Chinese Americans who are engaged in normal things you do, whether working in technology or working as a scholar in technology where they were targeted in spying, and it ended up being completely frivolous or pointless. And the point being that increasingly in the Chinese American community, this means there's a chilling effect. If you're a scholar in a research university and you are Chinese or Chinese American, you know that the government is prioritizing you and people like you for spying. And the question is, what are we giving up in terms of scholarship by making it clear that the FBI is collecting on that kind of communication?
Thank you. Okay, so Jumana, let's start talking about some of the known issues here, right? So these are impacts, these are theoretically calculated policy decisions. That's up to you and your bosses to figure out how to balance those. But there are things that we see from the outside, for instance, tracking court cases. And obviously there's nobody better than the NICDL to comment on what that looks like in the context of 215.
So yeah, I just want to echo what's been said, which, from our perspective, the issue is ultimately the authorities. The authorities which allow the government, any administration, to really reach deep into people's personal and private communications and activities without any kind of legitimate oversight and in a massive and untargeted way. Obviously, it can be used poorly against anybody, and it lends itself to being used poorly. And there's a number of things that that really make it easy for it to go down that way. One of them is the question of notice. So what does notice mean to you? I can tell you what it means to us. What it means is when somebody is accused in a criminal case, that they actually know where the information being used against them is coming from. It's a very critical piece of due process of allowing someone to build a defense, right? Because if you don't really know where the information came from, it's very difficult to build your case, to have a theory of the defense, to understand where exculpatory information may be, right? Because you don't know the source of the evidence against you. Section 215, and this is really critical, does not have a notice provision. What that means is if the government is going to charge you with a crime, and even really serious crimes, they never have to tell you that that information originally came from this kind of dragnet surveillance. It's critical, it's key, because there's no way of building a proper case if you don't know where the investigation started and how it proceeded. There's a whole set of things that are interesting. There's one case where we know for certain that Section 215 information was used to set up the investigation and the prosecution. And the only reason that was known, and this is super critical, right, because the lawyers defending the case had no idea as the case was going through the court that 215 was the source of information until, as the government was trying to argue to have the authorities renewed, they started describing a case where Section 215 was useful to a prosecution. Because other studies have looked and said, actually, you've not broken up any terrorist rings based on Section 215 authority. Why do you need this? And so they said, well, there's this very important case. And they sort of dug in and figured out, oh, this is our case. It's the case, the defendant's name is Milan. Okay, and it's still awaiting a decision. But the idea that after trial, because government officials are making public statements in order to hang on to a surveillance authority, you then find out that this information was used to charge and prosecute your client is extremely troubling. But notice by itself is not enough. You need notice, you need robust notice. But there's another surveillance authority that we're not going to get into today, Section 702, which does have a notice provision, where you're supposed to get notice if the information is used against your client in a prosecution. And there have been very few sort of dribs and drabs of notice given in cases, and part of the reason for that is the question of how broadly terms are defined. And this is another sort of critical piece that, for folks on this side of things who are not inside the government, who don't have the answers, we don't know how the government defines things like relevance and attenuation. And so I'm going to talk about those quickly and then move on from there. Relevance is key because when they start to do these sort of broad dragnet investigations, they're supposed to be relevant to something. And how you define relevance defines how broad or narrow the scope of that is. And I want to read a quote from ACLU versus Clapper, which was challenging these authorities, where the court said that to allow the government to collect phone records only because they may become relevant to a possible authorized investigation in the future fails even the permissive relevance test. Okay, and that's what happened with Mo Island. He was initially investigated in 2003, I believe, and they found nothing on him. And they were just sort of grabbing up records and keeping records. And when you talk about hops, it wasn't that they said that he was directly in touch with a foreign agent, but he was indirectly in touch. Again, what that means exactly, who knows? But the idea that you're going to just keep everything and then later on figure out that it's relevant because it might be relevant in the future, is sort of how the government can sort of stretch these definitions to where they have no meaning. And then there's a question of what they call attenuation, right? Which is, well, maybe we got the information starting with 702 or 215 or whatever authority, but that led us to this, which led us to the other thing, which led us to D and E and F. And really, once we got to F, it was so far out that we don't need to give you notice. It's too attenuated, right? It's a lot of ways in which what we call parallel construction, but really the government gets to launder their evidence against people. And it really keeps people from exploring, you know, where did this information come from? What is my theory of the defense? And is there Brady material? Now, again, Brady material means something to us. I'm about to describe it. I would never leave Brady on the table. It comes from a case that says quite clearly that the government has to turn over relevant information and potentially exculpatory evidence to the defense. They can't just sort of look at all the evidence they have and say, well, these few things over here really aren't going to help our case, and this thing, that's not important. We're just going to keep these pieces of evidence and only give them the ones that help our case. Right? That sounds like a bad prosecution, I would think, to anybody. Like, no one would want to be prosecuted under that theory. So that's what Brady is. The decision basically laid out that the government needs to turn over all relevant information to the defense and allow the defense to make their case, right? It's not like once evidence is presented in a case, it doesn't belong to the prosecution or the defense. It's evidence, and it gets to be used by both sides. And so, if, again, you don't even know that there is this whole other source of evidence, you don't have the opportunity to get that, and that's a very real issue in the Milan case. And I think, the last thing that I want to add is there's this question of metadata, which is what the CDR program is collecting, right, which is not the directly listening into your phone call or getting all the context of your calls, but all of the who did you call, how long did you talk for, kinds of questions, right, which some people have tried to say it's not so revealing. I think it's been much more widely talked about as very revealing information. How does this play in the wake of Carpenter? And the reason I ask that is because historically the government has argued, well, it's targeted, we have these search terms, we're not just collecting everything. Now, we're collecting these more discrete things, and so therefore there's no constitutional violation. Well, the Carpenter case, which went through the US Supreme Court, it was about historical cell site location information, right, which is a different type of data, but the case was, they were trying to figure out who's been robbing Radio Shacks, which, it started a while ago, because I'm not even sure there's Radio Shack anymore, but there was, I think, 3 separate robberies, and they collected 127 days of somebody's historical cell site location, which is the information that your phone carrier keeps on you that tells where you've been at any given time. 127 days to get information on 3 robberies, which I'm assuming did not last 40 days each, right? And so what the court found was that was way too much personal information for the government to be able to go get at this sort of lower standard without getting a warrant, without hitting a higher level of scrutiny, because it reveals all the privacies of life, right? And I think people would argue that massive collection and retention of people's phone metadata, even people who are not even directly accused of being connected to the source of, or with the selector, the actual person that you get the 2 hops from, is extremely troubling. And I think there's a large question in terms of definition that you as staff have an opportunity to find out, that we have a lot more trouble finding out, which is how is the government interpreting Carpenter in the context of their duties as to how they do or do not collect information.
And that's actually specifically relevant because a little bit more background here. 215 orders, there are 2 different kinds. So one is called a CDR program order. You've heard us talk about the CDR program orders. That's B2C under the law. Then there are traditional business records orders, quote unquote traditional. And under traditional business records orders, you can get location information because those are records. And it's an any tangible thing. So specifically relevant.
Well, I would say, at least as of 2014, the FISA Court was using a higher standard just because they were, but in any case, I don't want to say for sure that they are getting location data, but it's one of the questions that we need to have answered.
Fair enough. Marcy, we have only a brief period of time for this. Everybody in this room is going to hear from the government. What should they know going into those conversations? What did the last fight around a reauthorization look like? And I'm thinking in particular about the materials you wanted to show off.
This is the ask what we want?
No, this is the materials. This is the reauth. Those papers.
For example, one of Dan Coates recently said there's no record of abuses in the 18 years of this program. That word abuses is very interesting because in 2009, Russ Feingold said there have been abuses. And the FBI came and did some briefings in advance of reauthorization, and there is this moment where somebody on the House side said, what about all these abuses that Russ Feingold is talking about? And Valerie Caproni, who's now a lifetime confirmed judge in New York, answered, oh, there have been no abuses. And so this was an instance where a staffer was asking, kind of in the dark, because the staffer had seen what Russ Feingold, who was on the Intelligence Committee, was stating. And what Russ Feingold was talking about was an entire year of problems with the bulk 215 program with phone records.
Which was then secret.
Which was then secret. So Feingold knew about it. The rest of Congress did not know about it, anyone outside of the intelligence communities. And Feingold, all he could do, and we see Ron Wyden doing similar things these days, right? All Feingold could do was say, there have been abuses, and there were abuses. Effectively, what NSA was doing was treating these records according to a lower standard, according to the standard they use all their other records with. But the FBI didn't consider that an abuse. So when a staffer trying to figure out what the heck Russ Feingold was talking about said, what is he talking about? FBI just said, nothing there. Dan Coates is using the same word today, and there are handouts on the table which show that through the entire period, pretty much since 2001, there's been something going on wrong. Either the government's been collecting both content under Stellar Wind, but also more on point here, metadata without the normal kinds of process that you would need. And then from 2006 until 2015, they're collecting everything, or they're trying to collect everything in bulk, based off this kind of crazy interpretation of the law that was not public until Snowden came forward. And then finally, 2015 to 2018, the government's trying really hard to follow the new law under USA Freedom Act, but they're having problems technically doing it. We don't know what's happened over the last 3 years, 4 years, but what we know is that when the government gets these records, they're supposed to check when they get them and say, oh, is this what we actually asked for? Is this what we're actually authorized to get? And they were collecting, and about 3 years into the process, they're like, oops, we're not supposed to have these records. And they destroyed them all, which is a good sign that they really weren't supposed to have them and that they probably weren't on point at all. And so, well, that may have not been an intentional violation of the law. What it was, nevertheless, is a system that didn't have the checks and balances on it such that you could prevent violations of the rules and the law as it was written. And so there's never been a time when it's worked the way it's supposed to. That doesn't mean there's a bunch of people, trying to cheat or trying to break the law. It means there's never been a time when it worked the way it was supposed to, and the reporting mechanisms that are designed to ensure that it works the way it's supposed to were not themselves working. And so that's something that when Dan Coates comes to your boss and says no, well, it won't be Dan Coates anymore, but when Dan Coates or somebody else comes to your boss and says no abuses, you need to come back and say, but also, there's never been a time where it's been working the way it's supposed to. And that to us is an abuse because it's a violation of somebody's privacy. It means somebody's getting sucked up and either sent to FBI or NSA and subjected to a much higher level of surveillance than they should be for buying beauty supplies or for being 2 degrees of separation from their cousin in Jordan or something like that. And so that's the impact, is that completely innocent people are being subjected to analysis that they otherwise wouldn't be. And that's what happens when the program doesn't work as it's supposed to.
Thank you. And I want to turn to talk about some of the ideas that you all have, or that the general surveillance reform community has in terms of what should change. But also, Sandy, it's been a minute since we got back to you. Do you want to add anything to what's been said so far?
No, I agree with what's been said so far. I feel a little bit like I always sound like a little more alarmist than kind of people like detailing the programs, which is fine. Like the details are incredibly important. Yeah, I guess I just, I encourage folks to continue to be alarmed by this administration. It's easy to get exhausted by it, but these leaks are incredibly important, and like this is the administration that we were talking about. And again, as I fought against the Obama administration having these authorities, I do think this administration poses a unique threat. And to not talk about how these powers or how these authorities are going to play out in this administration feels a little tone deaf to me, because it's pretty clear. So I think that's what I'd add.
Thank you. All right, so Marcy, I have you up first for some of the ideas that you have for let's just say ways Section 215 can be improved, right? If we want to be just totally neutral about it, what do you think should change?
Okay, so when the USA Freedom Act passed, there were new mandated transparency rules. Those rules don't apply to the FBI in a meaningful way at all, and that should change, just so we understand the kind of impact that's happening at FBI. In addition, those rules don't count collection that is not communications related. So in the example of the beauty supplies that I raised earlier, if you're collecting beauty supplies on everyone who buys a certain volume of acetone or hydrogen peroxide, that's a ton of people. Those numbers aren't counted. And so the transparency rules that exist under USA Freedom Act should be expanded to cover those two areas at a minimum. FBI impact generally, and non-communication collection. In addition, one of the best parts of USA Freedom Act in 2015 is that it included language making it clear that Congress expected the FISA Court to ask for help when they had difficult questions. And that has been implemented unevenly. Last year, it looks like the court not only asked for help, but asked for help and allowed technical experts to provide some input, and allowed the primary lawyer they asked for help with to bring smarter people in, or people who had more technical knowledge. So that's a good thing. But in 2017, or actually it started in 2016, the 702 reauthorization, which is something that's still in the press a lot in the discussion of FISA abuses, that was one where the judge in question expanded the use of that surveillance. It was after the imposition of the amicus requirement. Either you use an amicus or you explain why you didn't. She had from September to April to ask for help. It was a very difficult technical question. She never asked for help. And I think it's highly likely that her decision, that her opinion as a result, which expanded collection at a time when she'd been told about long-term problems with the program. Why you would do that, I don't know. She didn't use the amicus. So I think the amicus language needs to be strengthened to make it more of a requirement. And I think some transparency on what you're collecting, especially in the age of increased use of license plate and face collections, I think Congress should make sure that this authority is not being used for either of those really impactful surveillance tools.
Sandy, what about you?
I think there's two that I'll touch on quickly that we are encouraging in any reform package. The first would be a disproportionate impact audit done by someone like the GAO, like an independent agency, to figure out exactly who they're spying on. And the second would be increased First Amendment protections. We need to make sure that there are basic protections built into these to make sure that people are not targeted based on their political beliefs or their religion or their associations, which we certainly believe that they currently are, whether that are immigrant communities and dreamers talking to folks overseas, or Muslims talking to people overseas, or Black Lives Matter like activists, which is a global movement. And so to ensure that those folks are not targeted based on their political beliefs.
Yeah, I'm just going to jump in with an example of why this is important. In 2008, the head of CARE, the
Council on American Islamic Relations.
Thank you. He was targeted probably inappropriately under FISA. Same kind of thing that Carter Page was. Under basically the CDR precedent at that time, the NSA and FBI would have been able to map out all of CARE, all of their clients. They're a legal services entity, right? So all of the clients that they were representing, their donors, because 2 degrees of separation gets you there, right? And we don't know whatever happened to that data. There's a lawsuit by the EFF in California to try and challenge the phone dragnet that for which CARE is a plaintiff, and it's just kind of sitting there on the books. But that's an example where people, their political rights, their religious rights, their political activism all got mapped out, and it should be impermissible under, I'll let you talk about the NDoubleACP precedent, but.
Yeah, so before I jump into a few other reforms, if you ever went to law school, you read NDoubleACP versus Alabama, which was a Supreme Court case that came out of the state of Alabama, who was trying to keep the NDoubleACP from operating in their state. They were not pleased about, a bid for civil rights, about the Montgomery bus boycotts, about all the other activities that the organization was undertaking, so they were seeking an injunction, and then in the context of that injunction, they subpoenaed a number of records, including NDoubleACP membership lists. I think, at least to me, it seems fairly obvious why that would be incredibly chilling on people's First Amendment rights. But the court, once they decided the case, also found, these were due process violations. And just to give you a quick quote from that decision, the court said, was immunity from state scrutiny of a petitioner's membership list here is so related to the right of the petitioner's members to pursue their lawful private interests privately and to associate freely with others doing so as to come within the protection of the 14th Amendment, which of course is the Equal Protection Amendment. And further, that freedom to associate with organizations is dedicated to the, quote, advancement of the beliefs and ideas that it's an inseparable part of the due process clause of the 14th Amendment. And so I just, in that context, this is not something that is sort of brand new, right? This is an established precedent in American jurisprudence that people should be able to associate freely and privately and not have that put them at risk of government surveillance.
And incidentally, the FISA Court did not do a First Amendment opinion on the predecessor of the CDR program until 2013. So until 7 years after it had been in process. And it's fairly clear that that analysis allowed suspicion by association. So again, it's back when this wasn't so easy to draw up these maps, these communication maps, it was clear that this was a problem. We need to get back to the point where we make it clear that drawing up these association maps is a problem.
I think, Sandy, did you want to jump in real quick?
Oh, I was going to kind of just wrap up with kind of the CDR program and the letter, unless folks have more.
Well, Jumana's up for
Jumana.
Your priorities.
She hasn't begun asking yet.
I haven't started asking. No, but I was always asking. So, in the context of some of the things that we would like to see, and I will say outside of just allowing the authorities to sunset, because frankly, that would be our first ask, to the extent that they do not, and that they continue to collect records in this way, whether it's business records, call detail records, et cetera. I cannot emphasize the importance of notice. It's what I talked about in criminal cases. And it seems like that maybe that's only relevant in this small section of, this sort of small piece of the world where criminal defense lawyers, have a client and need to build a case. But I just want to point out a couple of reasons why it's actually a lot more than that. For a lot of the folks who have tried to challenge these programs in impact litigation and civil cases, a lot of times what they run into, not always, but a lot of times they run into a question of standing, where the government says, well, you can't show us, the court said that you can't show a harm, you don't have standing to challenge this. There is no question but that someone who is accused in a criminal case who is facing the loss of their liberty has standing. It's a non-issue. It is absolutely certain that they have standing. And so that allows some of these things to get litigated and come forward. And what that also does is in many times it's through the criminal case that you get a peek into sort of how the government is using authorities that you don't get in other places. And so, however someone feels about Snowden, and I know even amongst our membership, people can feel very differently, right? He was either a hero or a traitor or, all of that aside, realistically, it's the only reason we know a lot of information. And so realistically, these sort of opportunities to actually uncover where evidence is coming from and how the government is, defining questions of relevance and everything else is one of the sort of key opportunities to understand how the government is operating these larger programs. And sort of another avenue of transparency, but also critical to due process in criminal cases. And that notice has to be robust, right? Not something that comes in sort of a buried line that if you don't know how to read it quite correctly, you would never know is the case somewhere at the bottom of a list, or that doesn't actually give defense counsel access to the information. And this is another point that I want to bring up. Many times we hear this information is so sensitive that if it sees the light of day, it's going to reveal all our sources and methods, the whole thing will come crashing down, everybody will have the information and be able to attack the United States. I think an important thing to remember is that there are defense counsel, defense lawyers, who get top secret security clearance to work on these cases. And their top secret security clearance is no different than anybody else's top secret security clearance. They absolutely understand what that means, how not to disclose classified information, how to operate in camera, how to operate within their ethical guidelines and do their jobs. And so that is, I think, something that needs to be mentioned in the context of this. There are many ways, even in dealing with highly classified and sensitive information. That's why we have the Classified Information Protection Act. It's why defense lawyers get top secret security clearances, that these things can still be noticed and talked about, even if it's not in open court, and still litigated in a way that will protect people's due process rights.
And I'll also jump in and say that the Snoopers Charter, which was passed recently in the UK, which authorizes the equivalent of a lot of the authorities we're talking about here, that lays out what they're doing. So if it's okay in the UK to lay out in general what they're doing with these authorities, and the authorities are shared back and forth, it's unclear why the US pretends they can't tell us in general what they're doing, because it's the same stuff that the UK is doing.
But yeah, and I think lastly, what I'll say is, one of the things in the Milan case, the case I referenced earlier, which had 215 authorities now revealed attached to it, it was also clear, because there was an other agency email, that was not the only authority being used in the context of this investigation. And the details of the case are problematic in a number of ways, that we can talk offline about it. But in keeping that in mind, I know this is this is sort of billed as a 215. 702 and other intelligence authorities have really critical fixes that also haven't happened, that allow the government to do a lot of dipping into information that's being collected under a much lower standard than the Fourth Amendment would generally allow, and then quite potentially being used in criminal prosecution. So to the extent that there is space, or you are interested in making space, right, before this discussion draft comes out or before the legislation gets introduced, we would be happy to talk you through some of the other fixes that would be really relevant and critical.
Thank you. Before Marcy, you want to say something? But Sandy, I think, was
Going to wrap us. I was going to do the IG.
But before the
Okay.
IG, we've got
Yep.
just a quick second, and we have the room until 11:30, but I figure everybody's got an 11 o'clock something. So please feel free to talk to us after the panel offline, and we'll have question and answer, and as much as we've got people who are able to join for more than the next couple of minutes. But Marcy, and then Sandy, and then we'll get to questions.
Sandy, then Marcy. I think Sandy was still on.
Yeah, Sandy then Marcy.
Okay, cool. I will be quite brief, because I think it's been talked about quite a bit, but just the elimination of the CDR program as a reform. Like, the public interest community across the board is on board that this program must die. It was shuttered at the end of last year. The government clearly cannot use it without abusing it. There's been massive abuse. So that is, at this point, low-hanging fruit, that the CDR program die. And I just wanted to flag that there is a letter over there from about 30 progressive organizations talking about a lot of these reforms that we're talking about here, and asking for those. It was to the House Judiciary Committee Democrats, asking them to oppose any bill that does not kill the CDR program and put in place a lot of these strong reforms that we're talking about.
Thank you, and I'm going to bump one more thing that Sandy opened with, which is, this bill is getting drafted as we speak, and historically, we've seen, and generally speaking, we know that it's difficult to change a bill after it's introduced. So if your office has priorities on this, now is the time. If you wait even more than a couple of weeks, it may well be too late to get that out there. And so I want to flag that for you, because I think that's the most important way to build a good bill, is to have voices represented in it. Marcy.
I think we also have an opportunity on another front, which is that there's this talk about FISA abuse, Carter Page, his FISA order. There are competing stories about whether that report is imminent or whether it's months and months away. And I think because it's not out today, this is an opportunity to talk about how FISA is used generally, and how the Carter Page order, even in its most worst possibility, is not as bad as a number of other FISA orders I can point you to around the country, around history, and Jumana, I think, can too. And that suggests that there ought to be a broader question about the role of FISA and the role of the secret court and the role of putting information into the criminal system that the source of which has disappeared. And I think there is a moment to be had right now, as we're talking about whether FISA is abused or not, to say, let's talk more broadly about the authority.
So if I could just add one last thing to that, I mean, I think when it comes to, because oftentimes, frankly, we would like to see it all go away. We understand that Congress is not necessarily going to make it all go away, but we continue to fight for access to information and transparency. So one of the things that came through in the last round was a discussion of the FISA court decisions, right? And writing them in a way that makes them easier to declassify, right? So sort of keeping all the classified sensitive information in sort of one part of the decision so that if you declassify it, it doesn't, look like a mishmash of chopped up pieces that are hard to follow, but also declassifying more of those decisions. And it hasn't gone quite as quickly as some of us would have liked. And I think an opportunity to sort of go back and look at that and ensure that we're getting the information, that we're getting the reasoning, that we're understanding how these decisions are made and how these things are being defined, not in a way that reveals all the classified information, but in a way that reveals some of the reasoning and the thought behind it. It really allows a much better look into how the program is being administered. And I think that's the kind of information that needs to be part of the debate.
Thank you. So let's take the time we've got and the time you've all got and switch to questions and answers. Does anybody have a question? Please. Oh, sorry. Actually, I was pointing to the woman behind you. But no.
Just generally, for those of us who don't have access to this classified information, that the Intelligence Committee briefs Congress on, where should people be getting better information about the way that Section 215 is actually used?
Who wants to jump on that?
Where we've got, to be honest, in the wake of Snowden, there was a lot of information that was released, which was actually, for 215, a lot of the orders were released. And if you spent a lot of time reading them, you could see what the rules on using them were. And so those have been summarized in a few places by a few people who've spent far too long with them. The PCLOB reports were useful, the Privacy and Civil Liberties Oversight Board reports.
And they have one specifically about Section 215, although it predates the USA Freedom Act.
But as Jumana keeps saying, one of the only places where you can find out how this impacts is in criminal cases. And so Milan is the only one we've seen that with. There is a counterpart criminal case that used similar dragnets by a guy named Hassan Shahi, which provides, again, some transparency in how these dragnets show up, and in his case, how they're used for authorities they weren't actually approved for. But that's one of the reasons why notice provisions are so important, is because we don't actually learn, what's collected or what is used or how it ends up putting somebody in prison unless that notice provision shows up someplace, or unless we kind of read through a detention memo, which is how I first figured out that they were collecting beauty supplies with it.
Where would you point somebody? I think that's all right, but I think a lot of staff don't have time to go into legal documents, court documents, and that's part of the problem, is that it's difficult for staff to prioritize this issue to the point that it's something that they can wrestle. Who would you point them to? Where would you point them for advice going forward?
You can follow Marcy on Twitter.
Follow Marcy on Twitter. There we go.
But I mean, there's a number of organizations that have information up. Obviously, ACLU, OTI. You all have a page.
We have our stuff over there.
There's a lot of people who spent time and looked at this information and distilled it in various ways. But Marcy's Twitter is a good place to start.
We also, for whatever it's worth, those organizations who are doing the work, they like to bring useful information to staff. That's a good part of the job. It's one of the best parts of the job, actually. So
Give Sean or Sandy a call.
Yeah, you're welcome to give any of us a holler. I'm sorry. The person behind you, yes.
And maybe I'm assuming people's positions on this, so you could say that you think it should apply. But what do you think the best argument is for not using the business records provision for geolocation?
Well, so one of the things that's not really known about the FISA Court is at least it had a history of when there is even a magistrate's opinion that challenges a secret program, they'll at least ask for briefing on this. And they did that in 2006, 2009 on geolocation. In 2014, Ron Wyden got them to say, for prospective location we default to a higher standard. We get warrants for that or a FISA order for that because there is a counteracting standard in one state. So in other words, they at least in 2014, were defaulting to the national standard. We don't know whether that's still true. There's very good reason to believe. The problem with 215 is you can get what is very meaningful location data without getting GPS data, without getting the location data from Verizon. One of my concerns about this program with the CDR program is that it, for the first time, required the assistance of providers. And given the history of a program that AT&T had called Hemisphere, they had a subpoena-based program where even cops, it didn't have to be the FBI, could go to them and say, can you give me the related numbers to this suspect? And AT&T on their own would use their own location mapping, right? And then the return to the cop or the FBI agent or whatever else would just be, here's a bunch of phone numbers that are common to this phone number. The government never got the geolocation of the suspect. What they got instead was a bunch of people who were geolocated with the suspect. They didn't do the analysis AT&T did. And so that is one of my concerns about the 215 program, is that because it requires assistance from providers, that the government would request that kind of assistance or other similar kinds of co-located. It's also important on the geolocation, this is sort of weedy, but the government, both on the intelligence side and on the criminal side, is increasingly getting orders based off of location tied to other apps. So, for example, I know of generally a case involving Snapchat, and some marshals asked for the geolocation of all of the people following a suspect's Snapchat, with the logic that he was a fugitive, with the logic that he was likely holed up with one of the people who was following his Snapchat account. The way in which Facebook tracks geolocation is even more terrifying, and there's good reason to believe that Facebook does track, like, if you go to a meeting of parents of disabled teens, that you will be geolocated for their purposes, and therefore they have the information for authorities to go get. So I think we're increasingly looking at with location generally, but I also, that's why I raise facial recognition, same thing with Facebook, right, and a lot of other, that if you go to providers and define a business record in a particular way, you're not going to get something that's prohibited under the law. You're not going to get the location data itself. You're going to get the provider to give you something that their own analysis has decided is either the same face or the same geolocation. Does that make sense?
I'd add just we've seen the Supreme Court say that there's a certain volume of one person's information that's a problem from a location tracking standard that's Carpenter and Jones, US v. Jones. Before that, 215 just produces a lot of information. And so there's one side is how much could it comport with the Supreme Court precedent as it now stands. And it's important for Congress not to mess with that precedent, right, to create a situation where a court has to say, well, does Congress want us to allow the government to use 215 for location tracking? At a certain point, it's a constitutional issue, but the courts are also going to wrestle with that statutory question. And then on the flip side, it's about everybody adjacent to those people. So 215, as the conversation I think has revealed already, is really about mapping connections. That's what the value of the records are. That's why 2 hops matters so much to the government. If you apply that to location, apply that to a cell site tower, you're talking about data that the government's made very clear that they will go to great ends to get and will push the law to acquire, and potentially with the effect impacting a very large number of people. And so I think not that you couldn't ever do location under 215, it's that it has to be a lot more tailored than it has been, because of the way 215 has been used historically and because of the value the government seems to assign to that location data.
Well, one other point about the vast amount of data that they're collecting, the Second Circuit opinion that found the phone dragnet under 215 unlawful discussed not just phone records, but also financial records, and said, having both of these together is a problem. The financial record side of this has not been addressed, and again, if 215 is just a grand jury subpoena, then you could get financial records with it. And I think there needs to be more of a discussion, not about what particular things you collect, but what things you collect. Again, if 215 is often used just to target a counterintelligence suspect, and they use it to get all of her stuff, right? Her phone records, her business records, her bank records, her X, Y, and Z records, and there's not ever going to be the same limits that you might see in a criminal subpoena, although even there aren't adequate limits. Then you're getting her whole life to find out, whether she's spying for China or something like that. That's when you begin to talk about mosaic. That's when you begin to talk about how much data accumulated in form really should only be obtained with a warrant, because you're getting so much, you're basically creating an entire dossier on a person that at the 215 level you don't have probable cause against.
Can I just make a quick addition to that? I mean, I think this is also sort of where the courts have been, where the Supreme Court has been coming in on this too, is that how the technology is changing. So even if you think about financial records, like long gone are the days where, you write a check sometimes, and every now and again for a big purchase you pull out a credit card, right? I was just in Union Station, I got a coffee at a no cash coffee bar. And so people walk around either with their debit cards, with their Apple Pay, with their whatever it is, swiping their life away, and then you took an Uber, and then you whatever else somebody did in their day, that very much creates a whole map of where you've been. And it's increasingly how our financial world is working. And so I think all of these authorities still need to be mapped against the way technology is changing what that information looks like and what it reveals.
Right, I mean, that's a really good point, is if you have somebody's credit card records, you don't need their geolocation. You know exactly where they've been, where Uber has taken them, and
where they rode their scooter.
Right.
Yeah, and for the record, we're also not talking about, actually the panelists aren't talking about the government never accessing the location information. It's just whether or not they need a warrant, or they can do it under the relatively low standard of 215. Does anybody want to add anything, or is there any more questions?
I want to make one more point that I meant to bring up. I said before that 215, the traditional side of it is increasingly used just with counterintelligence, not with terrorism. Nevertheless, when this gets reauthorized, the government's going to say that it's used to prevent terrorism. This is what came up on the 702 reauthorization. This is the kind of imagery that, this was Nunes, right?
Yes.
This is the kind of language that they use to scare your bosses into reauthorizing 702 without meaningful reform, using the marathon bomber's face. They're both important national security standards, counterterrorism and counterintelligence, but to the extent that the government doesn't want to talk about counterintelligence, they're not talking about both the impact. I talked about the Chinese American community, but they're also trying to make your bosses afraid. And keep that in mind as we carry out this conversation going forward.
Thank you. Any last questions? Oh, yes. This will be our last one, and then we'll close the panel.
As a Muslim and first generation American, this is a really important issue to me. So what tangibly can we tell our bosses to do before it's too late on this issue?
I'm going to invite everybody to respond to that, but I'll use this as a really as a moment to flag now is the time. Again, any priorities that you or your boss have, if you want them included, if you want them addressed during this fight, but that ends on December 15th, there isn't much time to make it clear to the people who are writing that bill. And so I just want to put that kind of fire under the question that's already obviously a very important one, and urgent one as well. But let me hand it to the panel.
So I'm going to sort of go off of, I promise Sandy is not the one who's just sort of waving the panic flag on her own. To put it in the context of what Sandy's talking about, right, and the FBI accessing this information, I think there's a larger conversation that's not going to be solved by this reauthorization debate, right, which is that the so-called racial profiling guidelines or guidance at DOJ is woefully inadequate in terms of preventing racial profiling. And, we get into then the FBI techniques and how they get to use them, it allowed the FBI to continue to do ethnic mapping and other really problematic sort of uses of people's information and figuring out who is where. And then so you start to lay all these things on top of each other. And it really is a good time to wave the panic flag, right? I'm with Sandy on that one. But again, this has been happening historically. It's been a systematic degradation of the protections that were put in place after, not just Martin Luther King, but anti-war protesters and all sorts of people involved in dissent were being scrutinized in ways that were completely unconstitutional. And so, there are reforms that need to happen in this debate, and I'm happy to talk to you about sort of where your boss is and what you might be interested in, but this should also be sort of a window into a larger conversation, right? Like a 215 authorization is a specific moment in time, but it needs to be part of a much larger conversation about, all the protections that have degraded, is that a word? Degraded, thank you. That have degraded over time since 9/11 under the context of sort of fear-mongering, and how do we come back to a constitutionally based system which can, serve state interests while still protecting people's constitutional rights and privacy.
And thanks, Jumana. This is COINTELPRO, which is considered a stain on our country's history. Like, that is what's happening right now, and that's a conversation that we should be having if Congress is brave enough to have it. But that conversation is certainly happening in the streets and outside Washington.
And it is right, and the FBI is increasingly getting close to admitting that white supremacist terrorism is the more urgent threat at this point of time. The conversation we need to have is FBI's prioritization choices. Because FBI, and Mike German, who is at Brennan Center and used to be an FBI agent, went undercover with white supremacists. He's got a book coming out this week, and he's absolutely genius on this. And what he says, and he knows better than anybody else, is it's not what the rise of white supremacist terrorism should show. And frankly, the FBI's success without even prioritizing it at cutting some of these attacks off before they happen is that the tools used against Islamic terrorism for the last 18 years, they didn't need those. Because they did perfectly fine with white supremacists. Yeah, well, international. This stuff, right? This stuff. They didn't need these tools. They used these tools to target immigrants, to target one religion. And if you look at the white supremacists, you look at the FBI's success over time, turns out they didn't need it. And if they didn't need it, let's rather than turn white supremacists into organized terrorist groups, because that's going to be used against African Americans and whatever, let's say FBI had the tools they needed, particularly in the age where you can get everything with a subpoena. Let's let these go away and instead put the FBI where they already have the abilities.
Yeah, and I just, as a matter of background, just to fly, so 215 is supposed to be used for counter-espionage, counterintelligence, and international terrorism. And so that's why the distinction between white supremacists who may be a domestic terrorist is significant relative to, a Sarnaya, where, and might help explain Marcy's point about, we've given the FBI and NSA additional tools to deal with one kind of terrorist relative to the other. Is that a fair way to describe it?
So I just want to jump in real quick, because I think this conversation about whether you need a crime of domestic terrorism, frankly, over time, the term terrorism has never really had one solid definition and is highly politicized depending on who's using it and for what, right? And so it's not as useful to, establish new crimes as it is to look at sort of what tools are needed or necessary. And if you look at things like over time, law enforcement will tell you that really if you focus on behavior rather than, groups, affiliations, et cetera, I mean, even Mike will tell you, Mike German will tell you, right? There are people who just show up at the meeting and he would be in these meetings to basically flag when somebody is saying, hey, we should all get together and, do this violent action. And there are people who are at the meetings like, whoa, hey, I just, wanted to be like up with white people. I wasn't trying to blow things up, right? That's, and that's sort of something, it's not the ideology, it's not the affiliation, it is the behavior, right? Of somebody who wants to take something to a next level, who wants to bring violence to different communities. And so, we've seen it like in the airport. It used to be more focused. This is pre-9/11. Obviously, 9/11 changed a lot of things, but there was a moment where there was a lawsuit where they had been focusing on, who is carrying drugs. And it was very much racial profiling. And a lawsuit was brought, and once they started focusing more on behavior, what they found, shockingly, not shockingly at all, was that the searches of people of color went down. They were also doing less searches. What they were doing is more fruitful searches and actually finding what they were looking for. And so, I mean, I think it's going back to also what's the question of good law enforcement practices, which gets lost, you know, when you're throwing out inflammatory flyers and talking about Islamic terrorism as if, you know, it can be attached to a religion or anything else. There is behavior, which may be seen as criminal, and then there are affiliations, which may be, you know, unsavory to people, but are not criminal per se.
And are protected in this country. And I think that's the thing is, on top of like the civil liberties argument that we sort of have all been pushing for the last hour, there is a real efficacy argument to be made. The NSA, the FBI were drowning in records and not doing anything with it, not finding it. Whereas when the FBI builds cases off of people who are associated, they seem to do reasonably well. And so, you know, even if your boss is like, well, I don't want to be seen as weak on crime or whatever, there is a real efficacy argument to be made. And I think Jumana and she can probably point you to 50 other cases where if the NYPD is stopping all men of color, chances are they're missing a lot of crime in other neighborhoods of the city. And that's what has happened in New York after they got rid of stop and frisk. And I think we're at a point finally where we can have a conversation about the efficacy of actually focused policing.
And to bring it back to your point, I think anything that you or anybody's bosses can do to drive that conversation forward is critically important. And it's one that's easily lost, even in these broader controversial debates around very controversial surveillance authorities. With that, I said I was going to end it after the last question. Thank you all so much for coming and staying for extra time, no less. Please feel free to come up and talk to all these wonderful people.